It's Monday, June 9th. It is day 29. 29 of the Karen Read Retrial. And the question looming large is this the last week of trial? It very well may be. Are we going to see the jury get this case for deliberation? They were told 8 weeks, and then they're told, well, we can't tell you how long deliberations will take, but 8 weeks for us to give the case to you. Is that going to be sometime this week? Because we know the defense only have a few witnesses left that we anticipate them calling. So it very well may go to the jury on Friday. One of the things that has stuck out to me from last week's testimony from Dr. Wolfe, who will resume the stand this morning after they're done with arguments, whenever they're done with arguments, after they're done with all of that, was about the gasketing of the taillight. I'm still stuck here. The gasketing of the taillight was so interesting to me that we have finally heard definitively where the bumpy clear plastic came from, which is the interior pieces of the taillight. I was like, what? I was shook. 2 trials, 8 weeks, and we finally hear that the inside portion of the taillight is what that plastic came from, and that 2 layers of taillight have to be broken to get there. It's not just the outer red layer of plastic that was broken, or a polycarbonate or acrylic or whatever he called it. Wild, wild stuff. Thank you, by the way, for making this the #1 place to watch live trials. And I think yesterday we were like the 3rd most popular show on YouTube in the US. So let's go, law nerds. Y'all are just ready. I'm ready too.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look.
I don't know if that's going to change things.
I'll direct you to here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
I don't know how you can see anything with that sweatshirt compressed down like that. But
When you were forming your opinions
the jury gets to decide.
that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did
Anna's
you
Banana
consider...
says, why does it look all wrinkled up? It looks like the shirt has slid down while it was standing up during the trial. It looks like it has just gone like...
that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry,
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
The court said everyone needs a break. I concur. Everyone needs a break. But it seems that we are finally done with Dr. Wolfe. And while we got into redirect and physics and force and mass calculations, my main takeaway before my brain absolutely melted was that, does the weight of the arm for the testing matter that much with regard to the damage of the taillight? The answer is no. It doesn't seem to matter that much for the calculations. And then Brennan wanted to ask a lot about the damage to the arm and lacerations, abrasions, tensile strength of fabric, and whether or not the fabric on the hoodie would have been ripped the same way or not ripped the same way, and whether it was studied that the fabric would rip a certain way, and whether the arm was heavier and or lighter, and that would change the road rash to the arm. But the last time they testified, the Commonwealth's expert, it was that the taillight fragments did the damage to the hoodie. And then as we got into the cross, then he started asking about whether or not the arm would be damaged by taillight. But so much got lost in the sauce, it was hard to follow Brennan through that line of questioning because there were good points of questioning. And then there was a lot of trying to just win cross-examination by being confusing. So at the morning break, that's where we're at. The argument over the voir dire of Dr. Laposata continues, and the defense said, no, we need more time for that. And now they are coming back into court after the morning break. So let us continue.
Your witness, is there a reason?
This is a separate issue. I'm asking Mr. Alessi to address the court on these.
Okay. What do you want to tell me, Mr. Alessi?
Moment, Your Honor, I need to put on evidence gloves.
I need to put on evidence gloves. Okay.
The defense moves for a mistrial with prejudice based upon intentional misconduct that
Alessi's got his mistrial voice on again, and he's now got gloves. Mistrial, asking for a mistrial with prejudice. He's got his mad voice.
the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. In what I'd like to do, Your Honor, this regards the Hoodie. In this regards questioning and representations in questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is...
That's why they were grabbing the pictures of the Hoodie. The Commonwealth picked up the Hoodie and was showing the witness, don't you see the damage to the back of the Hoodie? And y'all in the chat were like, but wouldn't we have pictures of those from the crime lab? Because the crime lab took pictures of everything and flagged everything. And in 2 trials, we've never seen damage to the back of the Hoodie. And the defense is sitting there with a picture of the Hoodie on the lectern. I can only guess that that's a picture of the back of the Hoodie.
Is to have 2 documents marked as exhibits, and then I am going to use exhibit 88, which is an evidence, which is the Hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
The defense is arguing that the prosecution pulled this and left those out of evidence on purpose because the damage to the back of the Hoodie is not road rash holes, it's clippings from the crime lab, which the prosecution would know.
Clarify this. Yes, are you willing, Mr. Martin? Let me just make sure I get...
Mr. Jackson, it says exterior front, what Mr. Alessi was pointing me to.
And that's a problem too. You're not the defense, Brennan. You can't just throw shit out and be like, couldn't it be this? Couldn't it be that? Couldn't it be lunch meat? Couldn't it be peaches? No, you're the prosecution. Do not take on the work of the special prosecutor if you want to ask questions like a defense attorney. There are different standards, which everyone else sitting at the prosecution table knows.
Your Honor, my brief review of the lab paperwork and looking at the Hoodie, it appears that I made a mistake.
Yeah, you did. But the argument is going to whether or not it was intentional.
And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolfe about holes on the sweatshirt or holes on the back of
there
Mr.
should be an
O'Keefe's
instruction.
Sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently. No way. No way do you get a stipulation that says this was done inadvertently. He does look rattled, but no way. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
All right. So I'm not going to allow the mistrial motion, Mr. Alessi.
It's
what I'm
curable.
going to do
Alessi
is...
doesn't agree. I don't disagree that it's curable. I don't think you tell the jury it's inadvertent, though. I think the court should instruct the jury when they come back in that they heard a line of questioning about holes to the back of the hoodie. And those were created by the crime lab. And if the crime lab testified, they would say that they made those cuttings, and then these are the pictures they took before the cuttings were made. I don't think the court should say it was inadvertent at all. I think it should be stronger than that.
What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence.
Well, 3 of Y and Z and 4 of A and B.
And I'm going to instruct the jury that during the cross-examination of Dr. Wolfe, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this.
Implying. Go with
I
implying.
instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th,
Because
2022.
Because they were made by the crime
I
lab.
instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please?
Yeah.
I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolfe about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi. Okay.
What is going on at defense table that pissed off the court? They must be talking to each other. That is purely my speculation, because the court was working with Alessi to reword this. If the defense is talking while she's reworking this on the bench, oh my God. I'm backing up to see exactly what she says.
Of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi. Okay.
Jackson said, Your Honor, I'm consulting with Mr. Alessi. I'm not showing disrespect to the court. But if he's talking to Alessi while the court is on the record, that is showing disrespect to the court. And if you need time, Alessi needs to say, Your Honor, can we have a moment to discuss the language?
All right. So it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January.
However, she's continued reworking it and telling them what she's doing instead of walking off the bench, which some judges would have done. So there is that.
January 29, 2025. Those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present in the sweatshirt?
Yes.
They were caused by the criminalist.
I said Alessi should ask for stronger language, and there it is. If the defense needs time to confer, you need to tell the court you need time to confer. You cannot confer while the court is talking on the record. And yes, Alessi is asking for stronger language. Good.
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolfe about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway.
Yeah.
All right, let's bring him in, please.
That's stronger language. Mr. Alessi is holding up the hoodie for the jury. with his evidence
Right,
gloves
jurors,
on.
that's the back of the sweatshirt that was shown to Dr. Wolfe.
And the jury's got to be like, what the fuck is happening?
Okay. Thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think we'll, Mr. Yannetti, your next witness, please.
Admit the other items of evidence. But no, we're not admitting those now. Okay.
There's a motion on Dr. Rentschler. We will give that, I haven't read it yet. We'll give that no more than 5 minutes tomorrow morning each side. This jury, you can tell just by looking at this jury, they're fed up. So.
After the voir dire of Dr. Laposata, the court ruled that Dr. Laposata cannot testify that the wounds on John O'Keefe's arm were from a dog. And the court differentiated her ruling between Dr. Russell and her ER experience vis-a-vis Dr. Laposata and her vast experience as a medical examiner and the chief medical examiner in Rhode Island. And the court said, I don't find that to be sufficient, which is surprising, honestly, because it seems like when you've done enough autopsies, that should be sufficient. However, I imagine we will see the defense ask about whether or not Dr. Laposata reviewed the findings of Dr. Russell and harken back to Dr. Russell that way, because Dr. Russell's testimony is already in and the jury has heard it. So I imagine what we're going to see is the defense asking in that way. What Dr. Laposata will be allowed to testify to is the original opinions about cause and manner of death, which seem to be the main point of her testimony, which is why they don't just have one doctor, why they have Russell and Laposata, because they did different things, and will be allowed to testify that she did not find the injuries to John O'Keefe's arm consistent with a motor vehicle collision. But she won't be allowed to testify that taillights are made of polycarbonate, but will be allowed to get into the injuries not being consistent with a vehicle collision. So I think at the end of the day, other than her not being able to get into more of why she believes the injuries to John O'Keefe's arm are from a dog, she will be able to get into why she doesn't believe those injuries come from a car. So that will be the testimony today and into tomorrow, because I don't think the defense is going to be done tomorrow. We've got Dr. Laposata, and then they've got Dr. Rentschler, who it seems like will be the defense's last witness. This has been a very fulsome day. The judge says that the jury seems kind of fed up. There's been a lot of non-working time in the court day today for the jury. So I'm not surprised that the jurors are frustrated as we are in the 8th week of testimony. And at the end, as the jury was getting ready to come in back from lunch, Alan Jackson was continuing to make a record that they had turned this information over to the Commonwealth. The Commonwealth did not make these objections during motions in limine and are making these objections now. And the Commonwealth said these are based on foundation. There's no foundation, and that's why I'm making the objection. The court said, yes, that's consistent with my ruling that objections can be made based on foundation at any time. So that's where we're at. Today has been one of those court days where I'm sure everyone is just like, you've got to be joking that this is where we're at. Everyone seems tired and frustrated today. It's been quite a lot, and I'm not surprised that the jury is frustrated.
The wound pattern suggested a ridge or ledged surface.
Yes.
Could you explain that in more detail, please?
Yes. So if I were looking at it, I would see the break in the scalp. Then I would see several sort of irregularly placed scrapes of the skin that kind of look like pencil marks. And so that means that something with granularity he hit first, then it moved up a little, broke the scalp and then moved on a little bit above that.
Would you expect to see that if Mr. O'Keefe had fallen backward onto a perfectly flat surface?
No, it has to be a surface that has some small ridges in it to make those little vertical patterns.
Thank you. Dr. Laposata, you just mentioned that the laceration above the right eyelid was consistent with the application of force, correct?
Correct.
You said it could come from some object, is that right?
Correct. It was fairly small. Could be, it's some sort of object.
Is it also consistent with a fist?
Sure, a fist is an object.
Okay.
After the jury was released at the end of the day, they went back on the record to deal with a number of matters. And this is not uncommon, especially as we are getting very close to the end of the case. The defense said that they are going to finish with Dr. Laposata, who is on the stand now, and then they are going to call Dr. Rentschler, and the defense expects to be done after those two witnesses. The Commonwealth said they think it'll take about 2, maybe 3 hours for all of their rebuttal witnesses. They are not calling Dr. Crosby their dog bite person. They are calling the DNA witnesses, which is the witness that swabbed the DNA from John O'Keefe's shirt, and then the expert that tested the DNA. That's like 15 minutes of testimony, 20 minutes of testimony. Then it's going to be at least a portion of a day where the jury is released for the attorneys to talk about jury instructions. I wonder if that's what they're going to do Thursday afternoon, because we had heard from the judge earlier on. She asked the jury if they would be able to work a full day Thursday, even though she had told them it might be a half day. I suspect with where we're at on scheduling at the end of today, Monday, that's probably on track to do the last arguments on the jury instructions Thursday afternoon when the jury's gone, and then do closing arguments all day Friday, get the jury the case on Friday. That seems to be kind of on track. And then the jury will get that half day, if not a full day, on Thursday so they can do jury instructions. They still need to have a full jury instruction conference. There's a lot of work left to be done in this case as we are speeding to the end of the defense's case in chief and the prosecution's swift rebuttal. I'm really surprised when they said it might take 2, maybe 3 hours at the most. I am stunned that that's how fast they expect it will go. I'm very surprised they're not calling Dr. Crosby after all of the fuss and all of the motions and all of the fighting and all of the everything over the dog bite expert from the Commonwealth who took the molds of the this and the that, and then they're not calling him. But also the defense is almost done, which means no Higgins, no Proctor, nobody named Albert. And it seems that the defense is going to lean into our experts are telling you this, and what hasn't the Commonwealth showed you? And of course, at the very end of the day, we heard from Mr. Alessi saying, Your Honor, excuse me, that instruction that you gave to the jury, that's not what we had talked about. So we're going to need to revisit that. And Alessi said he was going to file something at the end of today, and they're going to talk about that in the morning. The jury is coming in a half hour later tomorrow morning, which means they are going to do their motions on the record in the morning. So I will be here as close to time as humanly possible because I'm very curious. Will we have Zoom room tomorrow? No. Do we have tons of shit to talk about? Yes. But today has been another fairly unexpected day in court. I very much appreciate the defense expert that's on the stand. She is just starting to get into her opinions. I'm not surprised that they left that for tomorrow. So the main opinions from the defense expert we are going to get into tomorrow. Remember, in opening, the defense said there is no hypothermia here. So with the length of time that the defense spent on the background training experience of their expert, it's because their expert is contradicting a witness that I think the jury will like and other witnesses. And it's important to show the jury why you should trust one expert over the other. So at the end of the day, when the court's like, with the extended amount of time we spent on the background, it's like, yeah, the extended amount of time spent on the background. It's not just puffery. It's needed when you are going to be contradicting another witness. And the defense should have the time to do that. And I am not surprised Mr. Alessi is going to want to get back to the hotel, sit down, rewind, and watch that entire conference with the court and see what the court said and then what the court read in. Yes, they have the transcripts, but they also have the YouTubes. And the YouTubes are going to be much faster than waiting for the transcripts at the end of the day. I'm sure everyone in court is tired. And as you get to the end of the case, there is so much more work that needs to be done. It does not stop. The attorneys are working all over the weekends, and you can see the wear in court. You can see that everyone is a bit tired and ready to get this case to the jury. And it sounds like the jury is also tired based on the court's comments today. But these are important witnesses. But also, I wonder how people are going to read the court saying, well, this jury's ready to get the case. Is the jury like, okay, we saw the videos. This is what we think. Or is the jury like, fine, what are we doing? What are we doing? What are we doing? What are we doing? And I have to wonder if the jury is just exhausted. And we've had some very protracted cross-examinations. So when you have these long cross-examinations that seemingly go around and around and around, I'm not surprised the jury's fatigued. We've had one or two of those from Alessi, and we've had a number of those from Brennan. I think tomorrow we will also see the defense asking again about their expert, even though the court ruled today. I think we'll see the defense asking again because we've heard so much more of the background. I don't think the court's going to be inclined to change their mind, but you never know what's going to happen on cross-examination, and you never know what questions Brennan is going to ask. However, you also have quite a lot of information already in from Dr. Russell. I don't know if they need to get it in more because this coroner is going to testify, it seems, about cause and manner of death and then about consistency with a vehicle collision. So we'll see Alessi's motion. We will hear more about the slides that the Commonwealth has issue with from Dr. Rentschler and narrowing down those slides. Dr. Rentschler is still going to testify. The scope of Rentschler's testimony is not what the Commonwealth is arguing over. It was the wording of some of the slides. So that will get shifted. So the defense has actually gone faster than they estimated for their case in chief. And as much as the court wants to say, can we move it along? The defense can say no. I mean, the court's annoyed. The court's not going to be unannoyed. That's not going to change. But the court gave the jury an 8-week estimate. The Commonwealth said that they were going to be about 32 days. They really were about 32 days. The defense said about a week and a half, and they've moved within that and effectively within that. They have not lost a single juror. They have 6 alternates. If somebody gets to the 8th week and is like, and now I can't be here, you've got plenty of alternates. It's fine. And it seems that they're almost done. We saw Brennan apologize today, which is wild, but I think the admonishment to the jury was lacking in what the court said she was going to tell the jury. And I think that that is going to come back up tomorrow. Also, the court never admitted the other photos into evidence on the record that we saw. Could it have been done at sidebar? Yes, we just haven't seen it. And a lot of you asked, can the defense bring that up? Yes, the defense can bring it up and say, there's no damage to the back of this hoodie. They can show the photos. They can bring up the hoodie. They can say, you can ask questions all day long about this, but there's no damage here. This is from the lab. The court's admonishment was not as strong as was indicated. And I think it's fair for the defense to bring that back up. I'm not surprised that the court didn't rule it a mistrial. I'm surprised, honestly, that Brennan was like, that was a mistake. It was the first time I think we've seen him not fight over it and admit that that was a mistake and then basically say that he did his work hastily. Absolutely wild day. But I think a stronger admonition is completely appropriate. I'm not, again, surprised that there wasn't a mistrial. I think it can be cured by telling the jury that that's not what it's from. And then the jury will make the negative inference on the attorney that was asking that line of questions generally and not the witness, because the witness is like, I don't know what those are from. I think The prosecution is going to be real unhappy with the court bringing it back up again tomorrow because it points out again to the jury what an issue it is. But I think that's appropriate. It should be pointed out to them. And the court said she was going to tell them to disregard it. She did not tell them to disregard that line of questioning. She did not say on the record she was striking it from the record. She did not say they were to ignore it and not consider it, and that it is known that that was from the scientific services or the crime lab. Known. We need to see what's going to happen tomorrow, and having to do it again is just going to highlight it to the jury again. And I'm not surprised that the judge is saying the jury's fatigued. The jury's been fatigued for a couple of weeks now. As we get to the end of this case, it is exhausting for everyone involved. 8 weeks of trial is not short. We're just watching. We're not involved. The curveballs have been wild. Are we going to see this jury get this case by the end of this week? We will see. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.